Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, any views and opinions expressed in this podcast are those of the podcast creator alone and do not reflect or represent the views, positions, or policies of any organization, institution, or entity, past, present, or future, with which the creator is or may be affiliated.
Welcome to the Deep Dive. Today, we're digging into a really significant legal ruling out of India. It's one that could really change things for biotech and diagnostics there.
Absolutely. We're looking at how the High Court of Delhi tackled this tricky question. When does a technical lab process become an unpatentable diagnostic method? It's all about that balance between public health and, well, encouraging innovation.
Okay, let's get into the specifics then. The source document is the judgment itself. That's case number CA-COMM.IPD-PATI 7/2021.
Right, and that's from the High Court of Delhi, New Delhi. The judgment was handed down on October 9, 2025, and the judge presiding was Justice Pratibha M. Singh.
Got it. And the parties involved?
The appellant, the company challenging the decision, is EMD Millipore Corporation. They're a U.S. company, and they were up against the respondent, which is the Assistant Controller of Patents and Designs.
Okay, and the invention itself, the patent application at the heart of all this.
Yeah, that was application number 1226DEL 2012. The title gives you a clue. Devices and Methods for Infrared IR-Based Quantitation of Biomolecules. So it's about using IR light to measure stuff in samples.
Right. Sounds pretty technical. So walk us through the background. How did this seemingly technical method end up getting rejected by the Patent Office in the first place? What's the timeline here?
Okay, so the application actually goes way back to 2012. Things moved kind of slowly, and the first examination report, the FER, wasn't issued until 2017.
5 years. Wow.
Yeah. And while there might have been other objections initially, the big one, the one that stuck, was under Section 3I of the Patents Act, 1970.
Section 3I, that's the one that says you can't patent methods for medical treatment, surgery, or diagnosis on humans or animals, right? To keep doctors free to practice medicine.
Exactly. That's the core idea. And the controller basically said this IR method fell under that diagnostic exclusion. This refusal was made official in an order dated February 18, 2021.
Because the data it produced could be used in a diagnosis.
That was the argument, that providing diagnostic information made the method itself diagnostic, and therefore unpatentable under 3I.
But then things took an interesting turn during the appeal, didn't they? The court asked for another look.
That's right. Justice Singh asked the controller to go back and specifically look at the technical side, novelty, inventiveness, putting the Section 3I question aside for a moment.
And what came back?
That report, which came in August 2022, was pretty significant. The controller actually confirmed that, yes, the invention was novel and inventive. It met the criteria of Sections 2.1J and 2.1Y.
Okay, so technically sound, new, non-obvious invention. That really narrows the focus, doesn't it?
Completely. It meant all the technical hurdles were cleared. The only issue left standing was this legal interpretation of Section 3I. So the whole case boiled down to this single question. Does this specific in vitro analysis method count as an unpatentable diagnostic method under Indian law?
A really fine point, but with huge implications. So let's dive into the arguments. What was EMD Millipore pushing for? How did they argue against being excluded?
Well, their first major point was international acceptance. They kept highlighting, look, this isn't some fringe idea. We've got patents for this in the U.S., South Korea, and importantly at the European Patent Office, the EPO.
Ah, the EPO. They have pretty well-established standards for this sort of thing, don't they?
They do. EMD Millipore leaned heavily on a key EPO case, G0001004. That case breaks down diagnosis into several steps.
What are those steps?
Okay, step 1 is data collection. Step 2, comparing that data to norms. Step 3, identifying a deviation or symptom. And step 4, the crucial one, is the final deductive medical decision linking everything to a specific clinical picture.
Right.
And EMD Millipore argued, look, our method only covers the first 2 steps. We collect the data using our IR tech, and we provide a quantitative comparison. We don't do step 3 or 4. We don't identify symptoms or make the final medical judgment.
So they were saying we provide a tool, a piece of data, but the doctor still has to do the actual diagnosing.
Precisely. They also stressed the broad applicability of their method. This wasn't just for blood or serum.
You mentioned that earlier. What else could it test?
The patent claims explicitly covered analyzing samples from, well, all sorts of things. Food, water, sewage, cosmetics, even fuels. Not exactly the typical patient bedside scenario.
Yeah, testing sewage doesn't sound like practicing medicine. That broad scope must have been a key part of their argument that it's fundamentally an analytical technique, not purely a medical one.
Exactly. It showed the invention was more of a general-purpose quantitative tool.
Okay, so that's EMD Millipore's side. What about the other side? What was the controller, and I think you mentioned an amicus curiae, what was their argument for upholding the rejection? Why did they think Indian law was stricter?
Their main point was about the specific wording of India's Section 3I. They argued it's deliberately different and stricter than the European equivalent Article 53C of the EPC.
How so? What's the difference?
The crucial difference is that the Indian law, Section 3I, does not contain the phrase practiced on the human or animal body. That phrase is in the European law.
Ah, I see. So the argument was, by leaving that phrase out, the Indian Parliament intended to ban all diagnostic methods, even ones done in a lab, in vitro.
That was exactly their interpretation. They said the omission was deliberate, making the Indian exclusion broader. So any method that contributes to a diagnosis, whether on the body or in a test tube, should be barred.
And they linked this to public interest?
Yes, they brought up the principles from the big Supreme Court case, Novartis AG v. Union of India, arguing that allowing patents on these kinds of methods, even in vitro ones, could hinder access to diagnostics and go against the public interest focus of Indian patent law.
That's a strong textual argument based on the missing phrase. It really puts the pressure on the court to stick to the literal text or look at the practical consequences.
Right, because if you take that literal interpretation to its extreme, any improvement in lab analysis tech, any new software that helps interpret results could potentially be blocked if it has a diagnostic application down the line.
Which could really stifle innovation in medical testing technology in India.
That was the fear, and the core tension the High Court had to resolve.
So how did Justice Singh navigate this? What was the court's final reasoning? How did they balance the text, the purpose, and the practical impact?
The court went for what it called a narrow and purposive interpretation of Section 3I. It acknowledged the textual difference with the EPC, but focused heavily on the intended purpose of the exclusion.
Okay, narrow and purposive. What purpose did they identify?
The core purpose, the court said, is to protect medical and veterinary practitioners, to ensure their professional autonomy when they're actually treating patients, performing surgery, making clinical judgments, prescribing treatments. Those core medical acts shouldn't be restricted by patents.
So it's about protecting the doctor's action, not necessarily every tool they might use, like your microscope analogy earlier.
Exactly that. The court drew a clear line. Section 3I is meant to exclude process claims that involve direct intervention or judgment on the human or animal body. Think specific surgical methods, how to give an injection, or the act of diagnosing by looking at a patient's symptoms directly.
And things done in a lab in vitro.
That's the other side of the line. The court explicitly stated that product claims like kits, devices, equipment are generally patentable. And crucially, methods of technical analysis done in vitro outside the body are not automatically excluded by Section 3I.
Even if the results are used for diagnosis later.
Yes. The court looked at EMD Millipore's invention, this improved IR spectroscopy. It's done entirely in vitro. It provides, and this phrase is key, intermediate findings of diagnostic relevance. It gives you data.
But it doesn't make the final call.
Correct. It doesn't involve that final step of clinical judgment or attributing the data to a specific disease in a patient. The court essentially adopted the logic of the EPO's multi-step test, focusing on where the process stops. Does it stop at providing technical data, or does it cross into the final clinical decision?
So even though the Indian law's text is different, the court functionally aligned with the EPO approach to avoid, well, absurd results and encourage technical innovation in diagnostics.
That's a very good way to put it. The court reasoned that a technical in vitro analytical method like this one, which improves efficiency in this case, reducing calibration time, is precisely the kind of technical innovation the patent system should protect. Blocking it under 3I would go against the overall purpose of the Patent Act.
Okay, and you mentioned there was also a point about amendments. EMD Millipore tweaked their claims during the appeal. How did that play out?
Right, that's important for practical patent strategy.
Yeah.
During the appeal, they amended the claims, basically consolidating and narrowing them. One key change was adding a limitation about the diameter of the infrared beam matching the size of a specific area on the test membrane.
So it's getting more specific, more technical.
It was, and the question was whether this violated Section 59 of the Act, which stops you adding new stuff or making the patent broader than you originally asked for.
And did it?
The court said no, it was permissible. They found that this specific feature about the beam diameter matching the hydrophilic region was actually described in the original patent document, in the detailed description part, as a preferred way of doing things.
Ah, so it wasn't pulled out of thin air, it was already disclosed.
Exactly. Because it was based on the original disclosure and it narrowed the scope of the claim by adding a limitation, the court held it was an acceptable amendment, just explaining or clarifying the invention.
That shows a real attention to detail, making sure the final granted patent was solid both legally and technically. So, summing up the decision then, what was the final holding?
The High Court allowed the appeal. It set aside the controller's rejection order and specifically directed the Patent Office to proceed with the grant of the patent to EMD Millipore, a clear win for the appellant.
And just to confirm, were there any dissenting opinions, or was this a unanimous view from the judge?
The judgment doesn't mention any dissenting or concurring opinions, so it stands as the single clear decision of Justice Singh on behalf of the High Court.
Okay. This feels like a landmark ruling. What's the broader legal significance here? What precedent does this set for future patent applications in India, especially in biotech and health tech?
It's hugely significant. This decision provides really vital clarity on how Section 3I should be interpreted. It pushes back against an overly broad reading that could have stifled a lot of innovation.
So it stops 3I being used as a blanket ban on anything even remotely connected to diagnosis.
Precisely. It firmly establishes the principle that patent exclusions like 3I must be interpreted narrowly and purposively. It confirms that technical in vitro methods that generate analytical data are patentable, even if that data is later used by a doctor. This is a major boost for companies developing diagnostic kits, lab equipment, analytical software, and yes, AI-based diagnostic tools.
A big green light, essentially, for innovation in the diagnostic tools space.
Yes, as long as the claims are carefully drafted to cover the technical process and not the final clinical judgment itself.
All right, so if our listeners take just one single thing away from this deep dive, what should that absolutely essential key takeaway be?
The single most important takeaway is this. India's patent exclusion for diagnostic methods is focused on protecting the actual clinical judgment and intervention by a medical professional. Technical, in vitro processes that provide data for diagnosis but don't constitute the final clinical decision for treatment remain patentable.
The line is drawn between the tool and the final medical act.
Exactly. And the challenge, or maybe the opportunity, for innovators now is to be really clear in their patent claims, making sure they stay on the technical side of that line.
It's fascinating to see the court balancing these competing demands, international standards, local law, public health, innovation, a really critical balance for health technology going forward.
It absolutely is.
Yeah.
And this ruling clarifies one key part of that balance in India.
We've seen how the court handled this IR spectroscopy method by distinguishing the in vitro analysis from the clinical decision. But thinking ahead, what happens when the technology itself starts blurring that line? Say, an AI that not only analyses the data, but also outputs a highly probable diagnosis without direct human interpretation. Where will the line be drawn then? That feels like the next big challenge for the courts.
That's definitely where the cutting edge and the next legal battles are likely to be. Today's ruling sets the stage, but the technology keeps evolving.
Thanks for tuning in to the full episode. If there's any topic or case law you'd like us to cover next, share your suggestion in the comments on our latest video. And if you found value in the podcast, don't forget to like, subscribe, and hit the bell icon to stay updated.